probably off the first rental, but once it goes into collection, no.
Thank you.
Okay.
All right, Jack, I'm so glad I still have you with me, because you and I were talking about whether or not offline a couple of days ago you think a judge should be allowed to ask questions during a bench trial. And I said, I always did, right? But listen, the judge just asked the whole point of that testimony. You know, I'm assuming there'll be another witness, but to ask, was Penske paid in full? No. Did you get your commission? No. He really brought home, I think, the point of that witness.
Actually, I wasn't sure what the point was until the judge asked.
Yes.
So here's the underlying debate. People that haven't seen. We're texting back and forth, not just while this is happening, but sometimes afterward. My contention is this, is that the prosecutor always has the burden of proof. And the fact finder is the one who has to question what that means. My concern when a judge asks questions, and some jurisdictions are different, but my concern about judges asking questions is that what they're doing is they're filling in gaps that they don't understand. My problem is when they're filling in gaps, that actually takes that job away from the prosecutor. And it puts it in their hands, which shifts the burden. And I don't like that, because if what we saw before the judge asked that question was, well, wait a second, what's the point of this witness? I have no clue. And then the judge said, well, did you get paid or didn't you? This highlights that the prosecutor failed to do this, but it also highlights that the judge filled in the gap for the prosecutor. And that's my problem as a defense attorney if we're talking about burden of proof. How's that?
Right? No, that was a good answer, because you're right. It did fill in the gaps. It did answer what this witness knew. But I think also there's going to be another witness presented by the prosecution that is going to show Penske was never paid. But put that aside, it's an interesting issue because nationwide, we know, Jack, some juries get to ask questions, right? It just depends on the jurisdiction, on the court.
I hate that too.
I bet you do. I bet you do. But let me ask you one other thing in the last 30 seconds about the judge, because I think that you told my team that you're surprised the defense attorney is allowed to call his client Sean during questioning during why not, from your perspective?
I'm not surprised at all. I have done it myself and I get in trouble for it, because the reason is you're not supposed to even there. But what this lawyer is doing is they're sliding it in saying Sean. He just refers to him as Sean. And the reason is you're humanizing your client. You're trying to say, this isn't Mr. Harden, this isn't the defendant, this is just Sean. And you do that for a very particular reason. This is an old school criminal defense attorney. I love watching it happen, even though you're not supposed to. Is the rules a little sketchy? Yeah, maybe, but I'll take it.
And I think like it. And that's another example of the difference between the bench trial and the jury trial, because jury trial, I think prosecution may object to it, but when it's a bench trial, we know it's a judge. I don't think it's as crucial not to use a name to make them personal to the jury and really get them to like that person. All right, Jack, you're going to stay with us for the next hour, and what we're going to do is take a break. When we come back, guess who's on the stand? It's almost like we had a magic 8-ball. The Penske employee will take you back into court when we come back.
50 at joincalibrate.com.